Hey everybody, this is Josh for another episode of the Canadian Immigration Pros podcast. I am very happy to be joined today by Daniel Kingwell from Kingwell Immigration Law. Daniel, thank you so much for coming on the show today.
Thanks for having me.
I'm interested to jump in, Daniel. We are going to touch on some topics that, number one, we haven't covered on the show before. And number two, there's one or two of these topics that I have no clue about, which is very interesting personally for me. So we're going to talk a little bit about spousal sponsorship appeals, and then hopefully we have some time to talk about the deferral of removals, federal court stays. Again, don't know what half of those are, so I'm interested to dig in, and we know that you have plenty of experience to talk about them. Before we do, can you give everyone just a brief introduction, a little bit more about yourself?
Yeah, sure. So I've been practicing immigration law since 2001, which feels like an awful long time now. Right out of law school and articling. I was up for 2 decades at one firm, Daniel Kingwell, and I became a partner there. And in January of this year, I went on my own, started a firm, got a couple of great associates, good team, doing the whole range of immigration from litigation to corporate and applications. I'm a litigator. I've spent my career at the IRB in federal court and doing, we call it litigation, but really it's applications in anticipation of litigation as well. So humanitarian applications, rehabilitation, dealing with inadmissibility and enforcement, detention reviews, IRB, admissibility hearings, refugee claims, appeals, the whole range. So I like it. It's people who are in, immigration distress, let's say. But I like it because it's really the point where I can really help people get out of jams and never a dull moment.
I bet, and I'm assuming especially the last few years as well, right? I mean, especially since COVID and a lot of the changes that we've seen over the last few years, what I'm hearing, because I don't do file work anymore, is that
Mhm.
it's gotten even a little bit more difficult. Number one, just delays, the need for mandamus, reconsideration, all that kind of stuff. And so I'm excited to talk about this first topic because, as we know, spousal sponsorship, very, very popular application in Canada, permanent residence application, especially these days, I'm assuming, because, programs like Express Entry have gotten harder than ever. But what we
Mhm.
haven't talked about on the show yet is appeals for spousal
Mhm.
sponsorships, which you have a lot of experience with. First and foremost, can you just explain to everybody like how does an appeal work in Canadian immigration and then maybe more specifically, the process for spousal sponsorships?
Yeah, and well, it's a topic that's near and dear to my heart, and I should say I didn't when I gave you my history, I didn't give you my origin story. So when I was in law school, I expected to be a labor lawyer, and I took a year off of law school, went abroad, and I met my wife. So what happened was I came back expecting to do labor law, ended up, getting engaged and marrying my wife. And then I got a taste of the immigration system from the client's point of view. And I kind of went into labor law thinking, okay, I'm going to save the world, and this is where the work is, unionizing, workplaces. But I found out that wow, I'm married, but a bureaucrat gets to decide if I can live with my wife in Canada, which effectively means if the answer is no, I got to leave. And I've lived here my whole life. So I got a taste of that, and I got a taste of, how much it means to people. So I've been there, done that, and I went through, that whole process of trying to figure out, what does this mean? What kind of application do I have to file? What evidence do I have to file? So when we get to appeals, I mean, the first thing is to figure out the spousal application process, and there's a ton of misunderstanding out there about that.
Well, I gotta ask, can you continue that line of thinking? Because and I've certainly done plenty of economic applications, some of
Mhm.
which can be complicated, a lot of which are like
Mhm.
relatively straightforward. And
Mhm.
I would argue that spousal is on the side of being more of a, pardon my French, pain in the ass, right? It's a pretty long supporting document checklist, many forms, obviously more documents, some of which can be a little bit more subjective than something like, prove work history. So can you follow along with that thought in terms of like what are a lot of the misunderstandings that go into
Mhm.
preparing a spousal sponsorship? And then can you talk about like
Mhm.
what's like common cases where you obviously the applications are refused if you're going to appeal them, they're
Mhm.
not approved. So can you talk about like maybe some of the common reasons for refusal that might lead up to an appeal?
Yeah. So even before you get to the appeal, I mean, this is a little bit off topic, but one of the first things people have to figure out is, if the spouse is coming in to visit, for instance, one of the things I ran up against is what do you even say at the border? And, do you say, hey, I'm coming in to visit my fiance or not? And, the truth is, I won't name names, but I got all kinds of wrong information from not just lawyers, but even IRCC themselves. So, step one is trying to figure out what you even say at the border. Now, I mean, not to get into the misrep topic, but the answer is always tell the truth and be upfront when you come in, when you're coming in. So one of the issues people deal with is, should they come into Canada and make the application, or should they make the application abroad? But the broad point is to be transparent. I think the first thing that I always tell everybody when they say, "Hey, I want to sponsor my spouse," and usually when I meet people, they're in Canada. And so when we're talking about refusals, the first thing you want to make sure is that you're filing the right kind of application for you. So people figure, I mean, obviously there's the inland application and the overseas application. And that's the first question that people kind of don't even understand as a question. So if someone's in Canada, the first thing I have to explain to them is, well, if you're in Canada, you can file in Canada, but you can also file an overseas application even if you're here. And that kind of thing, what do you mean? I'm here. But the answer is you can file overseas. And I actually try to explain to people that the starting point is you're supposed to file overseas. The inland is an exception. So that's the first thing is people will get mixed up about which type of application to file.
Got it. So what
Mhm.
would be a good situation or, to file from inland versus outland? Or like
Mhm.
you said,
Mhm.
what would you recommend if someone came to you and said, "Well, hey, they're here already, but maybe they're just on visitor status. Maybe their visitor status is expiring soon."
Mhm.
And then I guess my follow-up to that is if they are in Canada, but you are going to file from outside Canada,
Mhm.
is it safe to assume that like what's their residential address? Is that their foreign like outside Canada residential address, or
Mhm.
what if they plan on waiting a little bit longer in Canada?
I mean, the question of residential is sort of a case by case, right? We could say they're here if they're, I mean, we usually say where they're actually living, right? But really, the answer it's not a one size fits all answer. That's the thing. It's a question of risk tolerance, I always tell people, and the pros and cons. So really what it boils down to is people need to understand, and nobody explains this to them until later sometimes when I see them at the enforcement end, that if you file in Canada, that doesn't give you status. And this is kind of a shock to a lot of people, right? I mean, as lawyers, we get to know this and we say, well, yeah, I mean, filing an application doesn't give you status. But the average person doesn't understand that. They say, hey, listen, I filed an application. I told immigration what I'm doing. What's the problem? Right? So they'd have to maintain their status. So the sort of basic question for us to figure out with them is, do we think that they can maintain their status while the application is processing? And application processing times are completely unpredictable. So what people don't understand is when they file in Canada, they're taking a chance that they're going to be able to maintain their temporary status while they're here. And so I usually, I mean, the sort of it's really a question of assessing the risk of removal. So if someone's from the United States or Europe and no issues of enforcement or anything, then yeah, it's probably pretty safe to file in Canada. But if someone's from a country where there's, it's maybe a poorer country or a country where you're less likely to be able to maintain your status, or they're already in the removal process or out of status, they need to understand that they might be removed. So we just want to make sure people understand those risks. You file in Canada, it might work out. It might work out great. You're going for broke, but you might also get removed in the middle of it, in which case then we get into
Right.
that enforcement process that I could talk about later.
Got it.
Mhm.
Yeah, I mean, we haven't even got to the appeal stuff, and this is super interesting because
Yeah.
the spousals I did were pretty simple. Like it was U.S. citizens, or
Mhm.
exactly like you said, European or U.S. citizens. So
Mhm.
nothing too complex. So let's talk about that appeal part. So let's say you submit the application. You're able to figure it out at least enough to make a decision to apply. You submit the
Mhm.
application. The refusal comes in. Now, obviously, number one, the refusal letters can be extremely vague, and I'm assuming
Mhm.
part of this answer is going to be an it depends. But what would you say are some of the most common reasons for refusal? And then the other thing I'd love to chat about is how do you decide between appealing, and it would
Mhm.
be great to hear about how that process works,
Mhm.
versus just reapplying?
Mhm. Right. So those are really good questions. And so just to tie it into what I was saying, So basically, what the people need to know is one of the main factors to consider is if you filed an in-Canada application, you do not have a right of appeal to the IAD. So that's actually that's the other major factor in deciding whether to file inland or overseas. It's really important. And people, again, are kind of like, people are shocked every step of the way because nothing is explained to people along the way. So if your inland application is refused, and I can talk about the typical grounds of refusal in a moment, but if it's refused, you don't get a right of appeal to the IAD, the Immigration Appeal Division. So that's where a spousal appeal goes. That's really important because if they're going to refuse you, and the typical ground would be that they don't believe the marriage is genuine, even if you're legally married, if you have a right of appeal to the IAD, then you get to go in front of an independent board member who is not part of the immigration department, who gets to make the final call and gets to hear you and your spouse and witnesses and evidence that we can talk about, and they get to make a separate decision. If you file in Canada, you can't do that. You got to file. You got to go to federal court, and it's a much more limited appeal, application for leave and judicial review. But it's a much more limited appeal on the merits. You don't get to go in front of another decision maker. So anyway, just to finish that thought, if we do think there's a good chance of refusal, then that would point us towards filing an overseas application. So
Interesting.
what are the types of the grounds of refusal? So typically, the ground of refusal most likely would be that they don't believe the marriage is genuine. And this is again a shock. There's a shock after shock to people here that I see, every step of the way, whatever point I meet them in. And so people are shocked to hear, well, wait a minute, I'm married. I've got the marriage certificate. And I said, well, that's easy to get, but they're assessing whether it's genuine. And so the question is whether it's genuine. Now, a lot of times people are interviewed, and, if they're unprepared, which many people are, it's like nobody expects the Spanish Inquisition. People walk into these interviews expecting just to be handed their paperwork, and there's someone sitting there tapping their finger, waiting to bury them, basically. I mean, they'll never admit it, but I think it's fair to say that most officers go into those interviews with a pretty strong opinion of the relationship. And so they'll go through these factors. I mean, you hope the interviewer goes through the factors, but if not, at the appeal, they're looking at different factors to assess whether a marriage is genuine. And I guess to tie it back to what you were saying about, whether it's an economic class or spousals, I think economic class applications, it's fair to say, is more of a science. It's more of you're looking at, identifiable factors. I mean, there's always an art to anything, but, the points and it's more hard rules that you're trying to comply with. Spousal applications is an art. They're trying to read people's minds, and they're trying to sort of look at the relationship from a distance and assess whether the marriage is genuine. Now, this was a shock to me when I went through it, and I thought this is terrible. But over the years, I've at least come to understand that unfortunately, there is a lot of marriage fraud out there. Doesn't mean they have shouldn't give them carte blanche to go after everybody and treat them that way, but there is a lot of marriage fraud. So they're looking for certain factors. And really what they're doing, I mean, it's an art, not a science, is they're just looking at, does this look, feel, act, talk, walk like a real marriage or not?
Right.
There are some factors that they're supposed to look at, and they do look at the IAD. But that's kind of the big picture question is, is it genuine or not? And often they say, well, no, we think this is an immigration marriage, refused. And then, if you have a right of appeal, you get to go and argue that again at the IAD on the appeal.
Right. That's a really helpful answer. I think my two big takeaways are, number one, the importance of the genuineness of the marriage, which I have a quick follow-up question about.
Mm-hmm.
And then number two, the opportunity to appeal from abroad. So it sounds like when someone is working with someone like you, who is very experienced, very intelligent, you know all the different options, really you should be asking a lot of questions at the very beginning just about, do we want to apply inland or not? Because it can actually have way more
Mm-hmm.
ramifications than even I understood. So this is very helpful to know.
Mm-hmm.
When it comes to genuineness of the marriage, I've definitely heard a lot of stories about the marriage fraud. For those of our listeners who, of course, are good people and genuine and et cetera, or maybe another way to say this is like for genuine couples, do you have any tips on, like, if they're getting invited to an interview or any particular whether it be pictures they're including or,
Mm.
like a couple tips on how to either beat the interview or, just prepare the strongest application possible.
Yeah. Yeah, for sure. And so I often explain to people, people go into this naively. I mean, look, I'm not going to blame them. I went into this naively when I and I was a lawyer, so I should have expected. But in any case, I kind of explain to people at a high level. I say it's not enough just to be a real relationship. You also have to look like a real relationship. There are I always say there are real relationships that don't look real for a variety of reasons, and then there are relationships that aren't real probably. I mean, I would never represent someone like that, but I'm sure, there are people out there but they work very hard to make it look real. So it's helping the clients understand that we need to show like a paper trail. We need to explain the relationship in detail. And so in terms of doing that, step one is let's get the story. Let's get the whole story. Let's not get we're not going to tell this like a Disney fairy tale, because that's not real life, right? Real life is ups and downs, bumps on the road. This family member doesn't accept it. There was a period of a breakup. Who knows? Maybe there was even periods of breakups and infidelity or all sorts. I mean, life is messy, right? So the first step, and the step that I tell everybody, is you gotta put it all out there. You just gotta lay it all out there, right? Because when it comes to officers and then ultimately IED, they're not going to trust the fairy tale, because life is not a fairy tale. So the biggest problem I see when I get it at the appeal stage is I said, look, they're saying we don't understand this, we don't understand that part of the history. It doesn't make sense. There's gaps. And then when I talk to them, they're like, well, yeah, actually we were, on the rocks, or there's this problem. This family member doesn't accept us. That's why we don't have any contact with them. And I said, well, why didn't you explain that? And they said, well, I was afraid. I was afraid they wouldn't believe me. The fear of not being believed, it's a bit counterintuitive, but like you've got to place your trust in the system, even if the system might, often makes mistakes and refuses you, especially at the interview stage. You have to put your faith in it and then just kind of lay it all out there. And ultimately that's what the IED is going to trust. So it's a matter
Right.
of telling the story, warts and all, and then documenting it. I can talk about the kind of issues in documentation, but that's step one, is getting the whole story out.
Right. And so would that be in the form of like a joint letter or an affidavit
Mm.
or
Yeah.
any of the
So,
above?
I mean, we like to do affidavits. I would suggest having affidavits because it's always stronger, but it's not required for the applications. Other than that, it's the paper trail. So photos, make sure the photos are all, chronological. Make sure it makes sense to the person who's reading it. So chronological, and just the, little captions, who, what, when, where, what's going on. Just showing, not a million of them, but just showing major events, and showing that you're interacting with family, friends, like it's public, right? So
Right.
photos, social media nowadays, right? Like if you're a real couple, I mean, if it's out there, make sure that's all out there and that's documented as well. They're going to check it, by the way, when they're doing the process. So there's that. There's proof you've been living together, sharing finances. If there's children, interaction with them, financial support. And what we like, I mean, really, at the end of the day, it's also affidavits and statements from friends and family. And they also should put down the real story, right? If there was
Right.
a family member that, was opposed to it and then had kind of a revelation where they kind of went, you know what, I think this is for real and I trust it and I overcame it. That's fantastic evidence. So affidavits from friends and family, put that all in, and then get ready for, to defend it in the interview.
Got it.
Mm-hmm.
Really helpful stuff. So let's say they take your advice, they do their best, they prep it all, they submit it,
Mm-hmm.
it gets refused.
Mm-hmm.
What's that next conversation like?
Yeah. So it's a shock to people because, nobody ever expects to be refused. I try to, so the thing is, at that interview, the officers, no matter what the truth is, the officers are going to profile it, most likely, at least at the beginning. And so if it isn't a fairy tale, if it's a short relationship, if there's a lot of distance, relationship, which we saw during COVID, right? If family members rejected it for various reasons, if the relationship doesn't fit culturally, like someone's in one culture historically and someone's in a different culture, or they're in the same culture, but it doesn't, like they're bucking the cultural trend, age differences, where it doesn't fit that, you know, two, people get together, they have this long dating relationship, and then everybody accepts it and moves on. Then, it could be refused, and that's a shock. But we try to kind of preview that. So what happens? You have to file an appeal to the IED. And I will say that, for people who want to get a sense of this process, the IED has a very good guide on spousal appeals that blocks out all of the major steps. So I'll just gloss over it, and people can read the details. But you have to file the appeal within 30 days of receiving the refusal. What happens next? And so then you're in for a long haul. So what I tell my clients is this appeal process could take, 6 months, it could take a year, it could take more. And that's actually really important for people to understand, because if they don't know that, then they're waiting like every day, every week, every month to be reunited. So then they're probably planning trips to visit each other. And so you file the appeal, there's a form. You're waiting then for something called an appeal record that is supposed to be produced within 60 days. That's basically the file from the visa post. You get that, and then once you've got it, you then have an opportunity to file documents in support of your appeal. So this is a fresh appeal. I mean, it's fresh in the sense that a new person is going to look at it. It's not fresh in the sense that all of the interview notes, the documents, everything that's been said and written is in the file and is going to the board member who's going to decide this eventually. So from there, you need to make sure if there's any mistakes or anything that was filed that was incorrect before, you're ready to address that, because you're going to be under oath when you get to the appeal. So if you made some mistakes, you're going to have to correct those. But otherwise, it's just filling gaps, addressing the reasons why it was refused. The refusal letters don't always have a lot of detail, but you can get more of a sense of it when you read the interview, and there'll be notes within it, like the GCMS notes will be in the appeal record. And then you prepare and you document it. One thing people need to know, if they're talking to people and they said, oh yeah, I had appealed 5 years ago, they've changed the disclosure deadline. So you have to file your disclosure early now, within 60 days of receiving the appeal record, not 20 days prior to the hearing, which it used to be. So that's one thing. And then you're waiting for your hearing, but they can have like there is an early resolution process that they engage that I can explain.
Yeah, is that something along the lines of like settling a JR kind of thing? Like, hey, if the government kind of looks at your maybe appeal documentation and says, oh, you know what, maybe we did screw this up. That's just the guess I'm taking. Can you talk a little bit more about that and how it would play out?
Yeah. So the settlement process, at least in the early stages in federal court, is more informal. This is a formal process. So the IED, years ago, decided that, well, hey, because they've got a motivation. So they're an independent tribunal, right? We're on one side, or the sponsor, now the appellant, is on one side. CBSA is on the other side. What the IED has decided is that, hey, we've got an interest in trying to settle this, trying to resolve this, right? Because we got too many cases. This was back when they had a lot of backlog. So what they do is they themselves will try to bring both sides in and say, hey, this is a bubble. This is confidential. Let's hash this out and see what the issues are and whether it can be addressed. And so you hope they don't always pull them out. They pull them out when they look at the file and they go, look, there's room for settlement here, not the ones where they know it's too, it's like there's not much room for negotiation. But where it looks like it's close, yeah.
What does that settlement kind of negotiation look like? Because I mean, it's pretty binary, right? It's either an approval or a denial, or I guess send it back for a reevaluation. So what does that look like even?
Yeah, and actually, because they've called it mediation or alternative dispute resolution, but you're right. There's only one resolution that the sponsor is going to accept. You can't like split the baby or split the spouse and say, okay, you're here 6 months of the year. It's either you're coming or not, and it's very unlikely that the sponsor is going to drop it. So it's really just an opportunity to address the concerns of the minister of CBSA that are on the other side. I have really mixed feelings about the early resolution. When it works, it's great. It resolves it early, and we can move on. But
so is it fair to assume that when it's resolved early, it's mostly in the case of having it approved or having it sent back?
Well, yeah, unless the sponsor is talked into dropping the appeal. I mean, there are cases where I guess they'll turn to the person and say, look, you're not going to win, or I don't think you're going to win. It's in a bubble. There's someone, like the mediator is someone from the IED that is usually, like, they're connected to the members, and they kind of look at it and they go, well, we think this is what the board's going to do with it. And if they'll say, I guess, if the case is really, really weak, they will turn to the sponsor and who's now the appellant and say, look, you're not going to win. You're probably wasting your time here. But, people will stick with it, at least the ones that I've got, because they're keen. It can, I mean, obviously what you're hoping is that the minister's counsel looks at it and goes, okay, you know what? Now I've got more information than what the visa officer had. I get it. You've addressed the concerns and we're going to settle this. And if that happens, then a settlement is drafted up. It's approved by a member. The person wins their appeal and it gets sent back to the visa post for final processing, and they can't refuse it for the same reason, for genuineness in this case.
Okay.
Otherwise, it keeps going to a hearing if it's not resolved.
Got it. And that was going to be my next question, because I found another kind of misunderstanding is when you appeal a decision in immigration, there's obviously different ways, as we've learned, IED, JR. Typically, winning an appeal doesn't mean your initial application is approved. They're sending it back. So that's good to confirm. So they're sending it back. It's still going to be reprocessed. And just to confirm what you said is they still will make a decision. It could be an approval or it could be a rejection. But if they reject it, it cannot be for the same reason, the initial reason that was settled. Correct?
Yeah, that's true. Unless, I mean, there's exceptions, unless some new evidence comes to light, right? But that doesn't normally happen. They're not supposed to dig for that. But they still have to do the other. If it's refused for genuineness and goes back, they still have to, do an updated security criminal. I always say that even though you cast that, if your spouse robbed a bank last week, that's a problem, right?
Right.
But otherwise, it goes ahead. Just to complete the early resolution, though, what I find is really why I have mixed feelings about it is because when you go in there, the board is not they're not making the decision in the early resolution. It's entirely up to the Minister's Council, CBSA, the other side, the people who have been against you up to then, to change their mind. And they don't have to give reasons. They don't have to change their mind. They just listen and they can say no. They can just say no. And that's it. End of story. And no matter how, and we're pretty successful at early resolution, but you'll get officers who just say no. And there's nothing I can do if they're going to say no and we've made our case. Nothing the appellant can do. And then it's the reason why I have mixed feelings is it can be very crushing for the appellant. They feel like they've lost, but I've said, no, you just got a free kick at the can, basically. We're still going to the appeal, and, I still think you're going to win. And, we've had many, many, many cases where we got an obstinate minister who just said no, and then we just go ahead and we win anyway, right? But it's crushing. It's crushing no matter how many times I say, look, it's entirely in the hands of the other side at that stage. It's disappointing, and I get that. But, we keep going, and, if the case is good, the case is good, and you're going to win.
Absolutely. No, that's very helpful. And so you mentioned earlier, Daniel, the timelines for going through a process like this. Does that also come into effect because, especially if they're applying from outside Canada, there's a couple options, right? I mean, is there ever a situation where reapplying is a better decision than appealing or JRing or something like that?
Yeah, and we see this a lot. Reapplication is not, is almost never the answer because, you're going back to the same decision maker effectively who already refused it once, IRCC. So, I mean, if you're going to, instead of going the appeal route, if you've put your best foot forward, even if you haven't put your best foot forward, you get a brand new kick at the can at the IED. It's a de novo process. So you've got your reasons for refusal. Go ahead and address it there. Otherwise, I tell people, when I see the people who went and reapplied and then they come to me for the second, let's say, refusal, I said, well, all you did was you put yourself at the back of the line again. So the line is kind of, you get refused. If you get refused, you keep going to the IED. Reapplication is almost never the answer, unless there was some technical defect in the application. But if it's for genuineness, if it's just like, hey, we don't believe you're a genuine marriage, keep going, keep going. And so, after the early resolution, then you're going to a hearing, and so to complete that story, you get your day in court. It's mostly by video now. It used to be in person, but you get to show up and you get to speak directly, just like this, to a board member, an independent board member who's going to listen to you. And your spouse also gets to testify by video, and they'll listen to them, and they'll listen to your family and your friends and anybody else who has anything to say. So that's your day in court. Don't keep moving, towards your day in court.
Right. Yeah, no, that makes a lot of sense. And I do think this is one of the reasons why we have this show, is because, I've heard the stories and talked to people who relied on random blog posts or random, YouTube influencers to get their information. You know what I
Mm.
mean? So
Yeah.
make sure you're getting information from good places. And then there's plenty of, and we've had them on this show, plenty of immigration consultants. The
Mhm.
really good ones work closely with lawyers, right? Because they understand, hey, listen, sometimes refusals happen, sometimes
Mhm.
court and litigation stuff is required that they're not licensed to do. And
Mhm.
so they do act in the best interest of their client. And if and when the time is right, they'll refer out or, set up
Mhm.
consults or whatever it might be. So anyways,
Mhm.
this is really helpful, especially because we do know that spousals are pretty popular applications. Can we talk a little bit, Daniel, about, especially because you mentioned the relationship between like potential unfortunate removals related to spousal sponsorship, like inland situations, but just
Mhm.
just in general, like what is a removal order, and what is the deferral process, even like for those who
Mhm.
might not have any clue what any of those words even mean in regards to Canadian immigration.
Yeah, so it's another, I mean, it's another area of litigation that I've been very involved with and I'm pretty passionate about. There's a ton of misunderstanding. And I mean, maybe to connect it in people's minds to the story we were telling. So let's bring it back to the inland spousal application. So someone files an inland spousal application, they gamble, whether they know it or not, they gamble they're going to be able to stay for that application. And then and then what happens is they're at a status. Their status doesn't get renewed, and then because they're at a status, they're issued a removal order. They're told to leave. What happens? And there's all kinds of different ways you can get removal orders, but that's one of them. So when that happens, so you're either you've got an application in process, and they say, well, you got to go, and you say, well, hold on a second, I've got an inland application in process, or I've got a humanitarian application in process, or I've got nothing in process, but I'm filing it now, something like that. If a person gets to the point where they're being removed, they can ask for a deferral of removal. And so this happens, there's a lot of steps to removal, but this happens at the point where all those steps are finished. There's a removal order, there's risk assessments, things like that. But when you get to the end point, there's a sort of a moment of truth where you go to CBSA in Toronto at 6900 Airport Road, and they say, okay, time's up, we're booking your flight. And this is a shock to people. I mean, there's shocks all along the way, but this is a shock to people. And a lot of people don't realize that there's a formal process where you can ask CBSA to stop your removal. And either they don't know it or they do it improperly. So what people need to know is that there is a process, and there's very tight timelines that you need to meet, and it's a bit of a dance that we've done over and over again with CBSA and eventually the court, that you need some experience with. And people need to know that that's available to them, but it has to be done by someone who's familiar with it. And I'm happy to walk you through that.
Yeah, what I would be interested in understanding is, and we'll definitely be sharing Daniel's information at the end for those who may need his services for whatever reason, what would be a situation where that is a good idea? Or is it always a good idea because
Mhm.
it's better to try than to be deported?
That's a good question, and it's not every case. I'll turn people away or strongly discourage people from applying in many cases because from experience you get a sense of like what's going to play in the end. You can say whatever you want about asking for deferral, and there are some short-term things. They're supposed to either look for short-term circumstances or circumstances that are sort of particularly compelling that I can kind of summarize. But one of the very common ones I would say is my kids are finishing their school year, so there are these short-term deferrals. For, hey, can you put it off for a few months until my child's school year is up? That's pretty straightforward, and they'll usually grant that. But when you're saying, hey, I've got an application in process, it's going to take a while, and I want to, I want to stay here during that process, or I have nothing in process, but I'm filing something now. You need to know if it's the type of case that they're going to defer, and it's not every case. There are exceptions, but I always say that the two main things we're looking for deferral that's going to stick is kids or risk. There are other factors, but those are the two things they're looking at most closely. Again, it's not the only thing, but those are the two things I look
Right.
at first. So if you have kids that are affected by the removal, they're settled here, they're in school, and you're suddenly going to be removed, you can and there's some application in process or when you want to file prior to removal, then that can be a factor. Or if you're in danger and, that hasn't been properly assessed in the system, there are refugee claims, things you can do, but if there's something new, whether it's individual or, a conflict situation in your country, those are the two main things we're looking at. What's surprising to people is they say, well, they can't deport my spouse, to tie it back. This is my spouse. I'm Canadian and this is the person I'm married to. And I said, you know what? Unfortunately, they deport spouses every day. Even children, if you don't present it right. Even Canadian citizen children, which is also a shock to people. How can you deport me? I've got a
Wow.
Canadian child. And it's kind of saying, well, you know what? It's not that simple. You have to make your case. So you have to put this, you put this in a deferral request, and there's very tight timelines. You get the removal date. So you go there, they book your flight. It's usually a few months, between when they book it and the removal. And that's your window to get the written deferral in. You can't do it before because there's no date booked. There's about a 2 to 4 to 6 week window usually where we ask for deferral. They say yes or no. If they say yes, great, they wait. If they say no, we're off to federal court on a motion for a stay of removal.
Right. Very interesting. So
Mm-hmm.
the kid part, obviously pretty
Mm-hmm.
self-explanatory. And then just to confirm, by risk, you mean like risk of what might happen to them if they get deported back to their home country.
Yeah, well, to be specific, like physical risk, right?
Right.
So the risk that I might lose my job, the risk that I'll lose my community in Canada, the risk that I'll be separated from my spouse, my brothers, my sisters, even sometimes my children. The courts have repeatedly said that in and of itself, unfortunately, is the normal result of removal. It sounds harsh, but
Right.
people need to know that that's what they're going to say. They're going to say, well, what's special here, right?
Right.
Well, my kids are, been here forever and are settled, and they're going to go to a country that they don't speak the language, or, there's a war in my country or some conflict, or I'm in danger and it hasn't been properly assessed. There are other situations, but, they're looking for something really unique.
Right. Yeah, no,
Mm-hmm.
that makes a lot of sense. And then
Mm-hmm.
maybe one of my last questions tying the whole episode together would be, so what if it's maybe a spouse that you're sponsoring
Mm-hmm.
and it's not from one of those, quote unquote easier countries, the US, Europe, etc., and you file inland in Canada and the processing is taking too long and they're about to, they're being removed
Mm-hmm.
and there is no really any, clear risk of the country they
Mm-hmm.
would be deported home to and they don't
Mm-hmm.
have any kids.
Mm-hmm.
What do you tell them if they call you up and say, "Hey Daniel, I want your help to try to defer my removal?"
When the application's been outstanding for a significant period of time, that would, I guess, be a third category that I should mention. Lengthy, it gets tricky because they are supposed to consider lengthy processing that, like, when an application's been sitting so long, and there's no magic number, but let's say close to a year or more, and then for whatever reason they haven't decided it and now they're removing the person. We can ask for deferral in that situation, but even then, there's something called irreparable harm we have to prove in court. There still has to be something that you're losing that's significant. And
Right.
so, I will look at that, and of course, if there's children affected or any kind of risk or anything, in addition to the lengthy processing, that's something we can raise. But this gets me back to my original point. You need to work with someone who can anticipate all of that. When you're going to file inland or overseas, one of the most important questions is looking forward in the process and figuring out whether you're going to make it, whether you're going to get that spousal application decided in time before removal. And if not, do you have something that's going to stick in court to stop your removal,
Right.
like the things I discussed? Otherwise, you're just walking into removal before it's decided. What happens then? The person gets removed, and then they have to reapply overseas. Start all over again, new fees, new processing time, everything. So to bring it back to my original point, that's why if you're anticipating it, if I kind of look at the case, or anybody who's experienced looks at the case and goes, you know what, you're headed towards a removal, you probably should think about filing overseas. People don't like to hear that. In fact, they're often surprised you can do that, but it's something that they need to consider.
Right. No, it makes a lot of sense. And one thing I've learned over the last few years is the
Mm-hmm.
importance of, because I never did litigation, I never did
Mm-hmm.
appeal stuff, I never did JR stuff.
Mm-hmm.
And what I've learned since starting this podcast and having people like you on is the importance of, especially these days, right? There seems to be more refusals than ever. Immigration's a little bit more complex than ever. And even when you're prepping that initial first application, or even deciding, as we talked about at the beginning, which
Mhm.
stream to even, or program to apply for, it's so important to know what might come after, what risks and litigation related or appeal related options might be down the road. So anyways, Daniel, wanted to thank you once again for coming on the show. Extremely, extremely helpful. I'm sure even some of the other immigration professionals who maybe like me didn't have this type of litigation experience, hopefully found it helpful, and of course, aspiring immigrants too. If anybody does want to learn more about yourself or the firm, or get in touch with you directly, or anyone at the firm, where do you recommend that they go?
Well, they can reach us. All our information's online. You can Google Kingwell Immigration Law. You can look at our website, kingwellimmigrationlaw.com. You can email me at daniel@kingwelllaw.com. So that's a different email. And our phone number is 416-988-8853. We represent people across the country. Things have become very remote, both in terms of meeting clients and even going to court and arguing at the tribunal. So, although we're based in Toronto, and we have a number of excellent associate lawyers and law clerks, we can represent people anywhere in Canada. And, we'd be happy to talk this through. These are the decisions you make, and the conversation you have at the beginning is going to decide years of your life. And the earlier you get the sort of roadmap, the big picture, the better. So, I'm happy to help. Please give us a call.
Absolutely. And we will have links to the website in the description below, whether you're watching on YouTube or listening on your favorite podcast platform. Daniel, thanks again for coming on the show. Really appreciate it.
Thanks for having me.